Hello, this is Professor James Strickler. This is a course in American government. This lesson is from Unit 7 about the judicial branch. It's Lesson 4 about the civil law. In this lesson, you'll learn about civil law, you'll learn about plaintiff and defendant, you'll learn about compensatory damages, punitive damages, contingency fees, and civil proof. In the last several lessons, we've been learning about the things that the American court system inherited from the ways that things were done back in England hundreds of years ago. We can call this our English judicial heritage. In the first lesson, we learned about the common law. In the second lesson, we learned about trial by jury. And in the third lesson, we began exploring the adversarial system. In particular, we looked at criminal law within that adversarial system. In this lesson, we'll continue to talk about the adversarial system. In the previous lesson, we talked about how the adversarial system can be divided up into two parts, criminal law and civil law. Having discussed criminal law in the previous lesson, in this lesson we'll now discuss civil law. We're going to look at four features of civil law: the offenses that are covered under civil law, the parties in civil law cases, the punishments available under civil law, and the proof required in civil law. Let's begin by looking at the offenses covered by civil law. Civil law deals with harm done. Now, in the background photo here, you see some people that have apparently gotten in a car accident and having an argument about whose fault it is, etc. That's the kind of thing that a civil law case would cover. And it does so whether or not the thing that happened is illegal or not. It doesn't matter whether a crime has been committed. The question is, was someone harmed in an unreasonable, unjustified way? What we would call negligence. That is what is explored in a civil law case. Okay, now that we know that civil law covers harm done to somebody, whether it's legal or illegal, doesn't matter. Now let's look at who the parties are to such a case. Remember back when we diagrammed the adversarial system in the previous lesson, that we saw that on one side we have someone called either a prosecutor or a plaintiff who's accusing somebody else of having done something bad. And on the other side we have a defendant who is saying that they didn't do the bad thing. Now, whether it's a criminal law case or a civil law case, the person who's accused of doing the bad thing will be called the defendant. But in the criminal case, the accuser was called a prosecutor. So in the civil law case, they're going to be called a plaintiff. So the party arguing that some harm was done to them in a civil law case is the plaintiff. They're the ones accusing the defendant of having done something bad. In other words, they're saying, you harmed me, and now I want justice in return. The plaintiff is usually a private party, but not necessarily. The plaintiff could be the government also. Yes, the government prosecutes people for having committed crimes, but the government can also be harmed. For example, if somebody were to damage government property, maybe the government would then bring a civil law case against them, called a lawsuit, and say, hey, I want you to pay for whatever it was that you damaged. Okay, so we now see that a civil law case deals with harm that somebody's claimed has happened to them, that the parties involved on one side, there's the plaintiff who accuses the other side of having done something wrong, and then the side that's saying, no, we didn't do anything wrong is called the defendant. Now we'll look at what punishments are available under the civil law. In other words, what might a defendant lose in a civil law case? Civil law cases are just about money, generally speaking. Now, there's some exceptions to that, not criminal sorts of things where you go to prison, but there's some other things that could potentially happen in civil law cases. But for this sort of course, the way to understand civil law cases is just to realize that generally speaking, they are about money. There are actually two kinds of damages that are sought in a civil lawsuit. One kind is called compensatory. The other is called punitive. Compensatory damages are where the plaintiffs are asking to be compensated for whatever harm was done to them. So, for example, I'm in a car wreck. I'm going to be asking for my doctor's bills for whatever injuries I sustained. I'm going to be asking to get my car repaired, things like that. I'm asking to have the actual damage that was done to me or my property or whatever it is, however I was harmed. I'm asking to have that actual damage paid for by the defendant. There are also, though, what are called punitive damages. Punitive damages are designed to punish the defendant so they'll never do the bad thing again. Now, let me give you a silly example to explain this. Bill Gates is the richest man in the world, worth $70 billion last time I looked at his net worth. So let's imagine that Bill Gates, as a hobby, loved to go around and slap people in the face. Just walk up on the street and slap somebody. Now imagine that person then, after getting slapped in the face, says, "I'm going to sue you, Bill Gates," and goes off and brings a lawsuit. Now, if they're trying to get compensatory damages, think about how much they'd have to actually be compensated for getting their face slapped. Maybe they went through a little bit of pain, a little bit of embarrassment. Let's be generous. Let's say that's worth a couple $100. Well, if Bill Gates only has to pay a couple $100 every time he slaps somebody in the face, that's never going to stop him from slapping people in the face. He can just walk down the street, slap people, toss them a couple $100, go up to the next person, slap them, toss them a couple $100, and do it for the rest of his life and never change his behavior. And so long ago, in the development of this civil law system back in England, it was realized that there would be cases where the amount of compensatory damages would be so small that whoever had done the harm would just continue doing it. So they came up with this idea of punitive damages, where you punish the defendant sufficiently that they'll never want to do the thing again. So you might look at Bill Gates and say, okay, what is going to punish him sufficiently that the next time he goes up to slap somebody, which, please, I'm not really saying that Bill Gates likes to slap people. It's my silly hypothetical. So what's the amount of money sufficient that Bill Gates, next time he goes up and thinks about slapping someone, he'll stop and say, "Oh no, I better not slap that person." What, maybe a couple $100,000? So when a person brings a lawsuit, they can not only ask for compensatory damages to be compensated for whatever harm, they can also ask for punitive damage to punish whoever harmed them enough that the person won't harm anyone else. And it's the person who brings the lawsuit that then gets that punitive damage money. Let me give you a real-world example of this. There was a case in which a doctor purchased a brand new BMW car. He then discovered that this brand new BMW car had actually been repainted since it had been produced on the factory. What had happened is it had been scratched when it was being shipped from Europe, where it was built, to the United States, where it was sold. And so the dealers, when they discovered the scratch on it, they had repainted it, but they had never told him that before he purchased it. So he had purchased a previously damaged and repaired car and hadn't known it until afterwards. So when he found out, he brought a lawsuit. Now, the jury ended up finding in his favor, and they first of all gave him compensatory damages. The compensatory damages amounted to $4,000 to pay him for the reduced value of his car. If it had never been scratched up and repainted, it would have been worth $4,000 more than what it was worth. So they provided him with that as compensation for his injury in having bought a damaged car without knowing it was damaged. But they also gave him punitive damages to punish BMW so that they would never want to fool people this way again. And what they awarded him in punitive damages was $4 million. Now, this is a rather extreme example, but it shows the kind of incentives that are created in this system, where if you're going to bring a lawsuit, it's probably handy to bring it against somebody who does lots of the kind of things that they did that hurt you, that has lots of money, because then when you ask for punitive damages, you can potentially get a lot of money. Now, this is particularly a problematic incentive because of the way that the lawyer system works in civil law cases. Typically, lawyers that are hired to pursue lawsuits on behalf of someone who's claimed that they've been hurt do so on what's called a contingency fee basis. Now, what a contingency fee means is that they get 1/3 of the damages won. So, in the case of the BMW owner, if they were only going to get compensatory damages, the lawyer handling the case for the doctor who bought the BMW would have only got 1/3 of $4,000. But by bringing the lawsuit for punitive damages also, that lawyer would then be entitled to 1/3 of the $4 million that the jury awarded the BMW owner. That's why you see lawyers advertising to try to get these civil lawsuit cases. It's not so much because of the compensatory damages that they're trying to get a chunk of. They want to get a chunk of the punitive damages that are awarded. All right, now we've learned about what sort of offenses are brought up in civil law cases. They're about somebody claiming they've been harmed. We learned about the parties to the case. Then on one side you got the plaintiff making the exact accusation, on the other side the defendant claiming they didn't do anything bad. We now know that punishments are monetary. In other words, people want money in the form of either compensatory, or I should say in form of compensatory damages and punitive damages. Now let's find out about the proof required to win a case like this. In other words, how sure must a jury be that the harm was actually caused by the defendant before they find them guilty in the case? Well, unlike in a criminal case that requires proof beyond a reasonable doubt, in order to owe damages, the jury only has to find that you're guilty by a preponderance of the evidence. Now, what does that mean, preponderance of the evidence? There's an easy way to think about it. Imagine a set of scales, and you put all the evidence that somebody is guilty in one side, all the evidence that they're innocent in the other side. Whichever side weighs more wins. In other words, if they're more likely to be innocent, you find them innocent. If they're more likely to be guilty, you find them guilty, even if it's a really close call. Let's think about it on a percentage basis. If you think they're 49% innocent and 51% guilty, you're supposed to say that they're guilty in a civil law case. Now that's a much lower, much easier standard of proof than is found in a criminal case. Let's use a specific example to illustrate how this might work out. Now remember in the previous unit about criminal law, we learned about the trial of O.J. Simpson, where he was accused of murdering his ex-wife and a waiter that happened to be there at the time, accused of slitting their throats. He was found not guilty at his criminal trial because the jurors thought that they had reasonable doubt. Maybe they thought that he was likely guilty, but it didn't matter because they had reasons to possibly doubt that he was guilty. So they found him, they let him leave without being convicted. After that, then, the family of the waiter that was killed brought a civil lawsuit against O.J. They said, wait a minute, O.J., you harmed us. You deprived us of the continued companionship of our son, who we claimed you murdered. And therefore, we want you to compensate us for that crime and potentially pay punitive damages to stop you from murdering anybody else either. Well, the standard in that civil lawsuit is a preponderance of an evidence. If we think about it on a percentage point scale, while beyond a reasonable doubt is way up near 100%, preponderance of the evidence is just barely over 50%. So if the actual evidence against O.J. Simpson, if we just imagine it on this percentage scale, let's say it's at 80%, then he would be rightly found not guilty in the criminal trial, but he would be found guilty in the civil trial. And that's exactly what did happen to O.J. Simpson. He was found not guilty in the criminal trial. He was found guilty in the civil trial and ordered to pay the family of the victim $30 million to compensate them for the loss of their son. Now, why would there be such a lower standard of guilt in a civil lawsuit compared to a criminal case? The simple answer is it's just money. Our society has decided that simply losing money in a civil lawsuit is far less important, far less serious, and therefore there can be a much lower standard of guilt than taking somebody's liberty away by throwing them in prison, or even worse, taking away their life through execution. Therefore, the standard of proof in a civil lawsuit is merely a preponderance of the evidence. Now let's review what we learned in this lesson. What supposedly happened in a civil law case? Was it that there was a law broken, or that harm was done to someone, or a license was granted to someone, or that a crime was committed? In a civil law case, the accusation is that harm was done to someone. Who argues that the harm was done? Is it a defendant arguing that someone hurt them? Or is it the judge arguing it? Or is it the plaintiff argues that they were hurt? Or the prosecutor that argues it? In a civil law case, it's the plaintiff who's claiming that harm was done. What are compensatory damages in a civil lawsuit? Are they about the harm done? Or are they paying for the harm done? Or is it time spent in prison? Or is it to pay to punish the defendant? In a civil lawsuit, compensatory damages are paying for harm that was actually done, compensating the victim for the injuries they had, whatever they may be. What are punitive damages in a civil law case? Are they the harm done to the person? Are they paying for the harm done? Is it time spent in prison? Or is the person required to pay in some way to punish the defendant? Punitive damages are about punishing the defendant, requiring them to pay more money in order to convince them not to do the thing ever again. What is a lawyer's contingency fee in a civil lawsuit? Is it a set rate they charge whether win or lose? Or do they get a percentage if they lose? Or do they get a percentage if they win? Or do they charge no fee, win or lose? In a contingency fee arrangement, a lawyer gets a percentage of the money won if they win the case. And finally, what level of proof is needed in a civil law case to convict someone? Is it probable cause, preponderance of the evidence, reasonable suspicion, or beyond a reasonable doubt? In a civil law case, the level of proof needed for conviction is merely a preponderance of the evidence. That completes this lesson. The next lesson from Unit 7, it'll be Lesson 5, about judiciability.